Very warm good evening to all. Today we will be discussing a topic under the head of section 313 of CRPC. Now 313 of CRPC, as everybody knows, it's a statement of the accused. When we go on with the criminal trial, and while proceeding with the criminal trial, the first part and the first chance is always given the prosecution to prove their story against the accused. Now, what happens if once the prosecution has completed their proceedings, the next part is accused is given the chance. Now, accused is given this chance. Accused is asked to some questions under section 313 CRPC. If you read section 313 CRPC, it is defined under the CRPC, which is say the accused is asked the questions, or the magistrate or the session judge will put up a few questions which has come in the evidence. Now see, whenever you are the attorney for the accused or for the defense, always remember that what questions are put to the accused, your client, under section 1313 is very important, and what is the answer you are giving. Always remember first thing, that never accept the guilt, because under 313 there are judgment which says that even if you accept there has to be corroborative evidence. The accused cannot be convicted solely on the uh, his admission in 313 CRPC, that's the 313 of Criminal Procedure Code statement. But always remember what, ask your accused client to listen carefully. What is the court asking? What question are put up to him, and then answer it. Okay, and then what is the material on which these questions are made by the trial judge or the trial court? Now here the material on which these questions are based is basically what are the witnesses. The complainant is the first witness. There are some witnesses and then investigation officer. What is 4, 5 or 10 or 25 witnesses, or maybe more than that, have said in their deposition. Now whatever has come in the deposition of testimony, the court will ask this person, this witness has said against this, has spoken against you about this is witness has said that you were present at the scene of offense. What do you want to say? This witness has said that, this eyewitness has said that you were with standing there with the knife, you have tried to uh, hit the person with the any weapon which you are having in your hand. Now these all questions will be put to your client, so he or she has to remember that she has to answer properly. If she fails to answer or he fails to answer it properly, it may be used against you. So always remember, whenever you're explaining your clients the statement under section 313, don't take it lightly, take it with all responsibility. Go through all the evidence which has been uh, produced by the prosecution, and what evidence has come, and this evidence, the question will be only on the basis of this evidence. Suppose there is a doctor which has been examined by the prosecution. Now doctor has been asked few questions, and what has come in his testimony, evidence before deposition before the court, these things has to be read in totality and has to be explained. Doctor may have said that this injury is possible because of this weapon, and this accused may have used this weapon. Now you have to tell your client that he has to deny or give a proper explanation. Now at the end of this 313 statement, after the complete questionnaire has been put by the trial magistrate court or the session judge, all this completion of the all the questions which has come in the deposition, which has been put up to your client, the court will ask 3 4 basic questions, whether your accused want to examine himself or herself on the oath, whether he wants to say anything on behalf of the of himself or herself, or he wants to give an explanation why the police have filed this case or why the complainant filed this case, whether he wants to give any witnesses or he want to produce any documents. Now these are the possibilities that the accused may want to examine himself on the oath as a witness. Now when he wants to examine himself, always remember he is subject to cross examination by the prosecution. When defense, that is me as a defense lawyer, is bringing the witness, which may be a the accused himself or herself or any other witnesses on his behalf, they will be cross-examined by the prosecution by the other side. Always remember this. Secondly, if he has to produce some document, it has to be certified true copy or the original document. If you produce the photocopies, then you have to say that you are producing the secondary evidence. Now, when you are producing the secondary evidence, always remember that the secondary evidence, you have to take the court permission. You have to convince, explain to the court where is the original, where has the, why you are unable to produce the original, whether and in whose possession original. There is a possibility that under section 91 CRPC, you can always tell the explain to the court, make an application to the court, and always call for the record from the other people if he or she has such documents. This you can bring before the court. Always remember this. So it is actually one of the very important part of the criminal trial. Sometimes this statement dispense with means court will not take the 313 CRPC, but these are the cases where there is no much evidence. If there is no much evidence, court may dispense with, court may not take 313 CRPC. In that case, you have to understand there is no much evidence. So court will dispense with the 313 CRPC statement and it will post directly that matter for the maybe for the arguments or may post it for the judgment. So there you get an inclination from the court. There is no much evidence against your client and there is a possibility your client may get acquitted. So always remember 313 CRPC is very important part of the trial and this stage has to be explained. Your client cannot go just like to the court and say what are the questions, because sometimes the client is unable to answer, and if he or she is unable to answer, then it may mar the complete trial which is run by you very successfully. So always explain the client what are the likely questions under section 313 CRPC. And the court may put one question which is very important: why the complainant and other people are deposing against you. So this is very, very important. So you have to answer why they have filed a false case against you. What is the reason? And this explanation is very important. It should be convincing to the trial judge. So always remember 313 CRPC. If you take it seriously, it may help you somewhere. There are some judgments where the High Court or the higher courts have actually, or Supreme Court have actually overturned the conviction into acquittal because of the 313 statement. There was some discrepancies in those statements. They were not taken properly, or there were some situations which have come in evidence which was not put to the your client. The client or the litigant accused has to be given an opportunity to explain what has gone against him or her. So this was all about 313 CRPC. Today Munmun will be reading a piece of article on the forgery. Munmun is from Assam. Thank you so much for attending all the way from there. Munmun, kindly unmute yourself.
Am I audible, ma'am?
You're audible.
Yeah.
Just a minute. This is judgment from Calcutta High Court. Hiral Banka versus Mr. P.S. Bose and others of the year 1993. Munmun, you can start from here. Munmun, you can begin.
Yeah.
Is it visible? Yes.
Yes, ma'am. This revisional application has been filed for quashing the first information report dated the 27 June 1989 in RC9 SCB 89 Calcutta, and all proceedings initiated thereunder in the Court of the Learned Subdivisional Judicial Magistrate South, Alipur, Calcutta. The said first information report is Annexure E to this revisional application. The FIR was recorded at the Delhi Special Police Establishment CBI SCB Calcutta branch on 27 June 1989 under sections 120B, 420, 468, 471 IPC and sections 277/278 of the Income Tax Act 1961 on the basis of information reported in writing by one Shri P.S. Bose, Inspector of Police, CBI, SCB, Calcutta, who also took up the investigation of the case as per order of the SP, CBI, SCB, Calcutta. In the formal part of the FIR, the name of the complainant has been noted as source and the date and time of occurrence has been recorded as during the years 1985 and 1986. 7 persons, including the 4 petitioners herein, have been named as accused in the FIR. The gist of the allegations of the FIR is noted below. Mahesh Kumar alias Mahesh Chandra Bhangchak and the 4 petitioners, namely Hiralal Banka, Sumit Banka, Nisha Agarwal and Nisha Banka and Sudesh Banka, all of Calcutta, earned huge sums of money through unauthorized sources, resulting in accumulation of large sums of unaccounted money, which they were required to disclose to the concerned income tax authorities. But they avoided to do so for evading payment of income tax liabilities, as has been reliably learned. It was further disclosed by the source that the above named persons in contact with Om Prakash Mittal and Gopal Chaudhary, both of Siliguri, and Udairam Agarwala of Gangtok and others, mutually agreed to commit illegal acts and adopt illegal means to account for the unaccounted, undisclosed, unexplained amounts of money under false and fictitious cover of receipt of gifts from the contact man said Udairam Agarwala of Gangtok, Sikkim, where the provisions of Income Tax Act 1961 do not apply. In furtherance of the common object of the said agreement, Mahesh Kumar alias Mahesh Chandra Bhangchak, Hiralal Banka, Nisha Agarwala at Banka and Sudesh Banka passed on their undisclosed, unexplained, accumulated money to their contact men in Sikkim through the middleman Om Prakash Mittal and Gopal Chaudhary, and the said contact men of Sikkim, Uday Ram, in turn disclosed a major portion of the amount so passed over to him to income tax authorities of Sikkim for nominal turnover tax, and on declaring that he had given a gift of rupees 7,10,000 to the aforesaid 5 persons of Calcutta through bank drafts purchased from Central Bank of India, Gangtok, Sikkim, in favor of the aforesaid 5 persons of Calcutta, payable at the branch in Calcutta, and the said 5 persons received the said amount in their bank accounts at Calcutta, and thereafter they reflected the same as gifts in their books of accounts and filed income tax returns before competent income tax assessing authority, disclosing their unaccounted, undisclosed, unexplained money as receipts of gifts, as thus claimed exemption from payment of income tax liabilities, and in support of such claim they filed photostat or xerox copies of affidavit obtained by their contactmen at Sikkim from the competent authority at Sikkim. The recipients of the so-called gifts thereby succeeded in getting exemption from payment of income tax liabilities on dishonest and fraudulent misrepresentation of facts in their income tax returns. But for such dishonest and fraudulent misrepresentation of facts, the income tax authorities would not have passed order accepting the claim of benefits of gifts. It is thus palpably clear that for perpetration of fraud, false declarations were made intentionally by the said persons in Calcutta in their income tax returns, and false documents were used by them with full knowledge and having reasons to believe that such documents were forged. The aforesaid transaction involved misdeclaration of amount 7,10,000 of unaccounted, unexplained money and proportionate evasion of income tax liability. The above facts prima facie disclose commission of offences punishable under Section 120B, read with Section 420, 468, 471 IPC and Section 277 and 278 of the Income Tax Act 1961. What is described above in this paragraph is the reflection of the allegations in the FIR. From a reading of the FIR, it is evident that the matter relates to submission of income tax return at Calcutta by the petitioners, allegedly supported by false and fabricated statements and materials showing gifts of money received from some other person of Sikkim, to whom allegedly the petitioners had earlier passed on their undisclosed, unaccounted, accumulated money for evading income tax and obtaining of relief thereby in the matter of assessment of income tax to which they were not legally entitled. It has been argued by the learned advocate for the petitioners that since the income tax authorities themselves have accepted the returns and have not questioned anything in that connection, the police authorities or for that matter the CBI cannot start an investigation in respect of the self same matter for harassing the petitioners. It is also submitted on behalf of the petitioners that under the Income Tax Act, the income tax authorities themselves have power and responsibility to take appropriate action if it is felt by them that anything wrong has been done by the petitioners in connection with the submission of their income tax returns, but it is an act of gross arbitrariness and wanton illegality on the part of the CBI to embark upon a harassing investigation without any authority of law in respect of the matter of income tax assessment made by the income tax authorities. The two sections of the Income Tax Act which have been mentioned in the FIR as attracted to the facts and circumstances are sections 277 and 278. The said sections of the income tax are reproduced below.
Wait.
Section 2.
Wait. Sections are
Yeah.
related to income tax. And this is all income tax.
Okay.
It is this para 11.
Okay. The learned advocate for the opposite party, CBI authorities has relied upon certain reported decisions which one discussed below. In Dhanalakshmi versus R. Prasanna Kumar, it has been observed by the Supreme Court that in proceedings instituted on complaint exercise of the inherent power to quash the proceedings in called for only in cases where the complaint does not disclose any offense or is frivolous, vexatious, or oppressive. It has been observed by the Supreme Court in the said decision that in quashing the proceedings, the High Court was clearly in error in assessing the materials before it and concluding that the complaint cannot be proceeded with. It is needless to mention that the said decision has no application to the present case in as much as the present case has not been started on the basis of a complaint and the proceedings is not going to be quashed on the ground that the allegations do not constitute any offense. The proceeding, on the other hand, in this case is found liable to be quashed on the ground that the police have no authority to investigate the case in view of the specific provisions of law applicable to the matter. In State of Bihar versus Raj Narayan Singh, the Supreme Court did not approve of quashing of the proceeding due to discrepancy appearing between the first information report and the statements of witnesses recorded during investigation. In the present case, the proceeding is found liable to be quashed on grounds of law and not for reason of any discrepancy between the FIR and statements of witnesses. The said decision in this is therefore not attracted to the present case. The decisions in state of Haryana versus Bhajanlat, the Kurukshetra University versus state of Haryana, Nagawa versus Biranna, AIR 1976, SC 1946, Jehan Singh versus Delhi administration do not apply to the facts of the present case, because in none of those decisions it has been held that the High Court has no power to quash an investigation by the police, even when it is found that the police in the facts and circumstances of the particular case have no power to investigate the same. On the other hand, in the decision in Nagawa versus Viranna Supra, one of the principles formulated by Supreme Court for quashing a process against the accused, in where the complaint suffers from a fundamental legal defect such as want of sanction or absence of a complaint by legally competent authority and the like. In the present case, as I have elaborately discussed, the police, in view of the specific provisions of law, are not entitled to investigate a case of this nature. If the petitioners have evaded proper assessment of income tax payable by them, and if for doing so they have made false declarations and have forged and fabricated materials and used the same for hoodwinking the income tax authorities, in that event the income tax authorities are themselves competent and required to take appropriate action in the matter under the provisions of law, not only for prosecuting the offender but also for reassessment of income under section 147 of the Income Tax Act. But the income tax also for reassessment of income, authorities have not considered it necessary to do anything of the sort in this matter. At any rate, there is no report of any such action on the part of the income tax authorities. Be that as it may, the investigation in the matter by the police or the CBI being distinctly unauthorized in law, it is incumbent upon this court to quash the same in exercise of its inherent power.
Wait. Thank you so much, Manu. Very well read.
Thank you.
Now, this was a judgment related to forgery. Now, if we read, this is an old judgment. In forgery, there is no much changes. There are many sections which are devoted in the IPC to this section. They start from 469, 470 onwards. Try to read it and see this 420, 468, 471. Some of the sections are valuable, some are non-valuable. It also speaks about the valuable security. Now, if there is a electricity bill, if it has been forged, then for somebody it may not be a valuable property. But whenever, if it is in my name and somebody misuses it, it is a valuable property. This is a piece of paper. This is not valuable, and somebody comes to my office and take away this. Then it may not be a valuable property, and there is a money which is a price is also described under the act. But now, as per the see, 100 rupees was something which was very big thing a few years back. But today, when if the property is valued more than 100, then it may, according to law, it may be more very valuable property. But here, if there is a book, the police also may not take the cognizance of the same. But suppose it is the electricity bill, which is one-page paper, but it is a valuable property. Mind, electricity meter and electricity bill is my property. Nobody can use because it is in my name. So always remember, forgery is a very clean subject. And if you go on reading it, it is going to help. So I have started reading judgments related to this. So thank you, Munmun. Now we will go to the legal vocabulary. Just a minute. These are few words I have taken out from the judgment itself: dismay and discomfiture. Now dismay and discomfiture is like it's awkwardness, and dismay is the Hindi word is nirasha hona, nirash hona. The dismay and discomfiture received by him in court proceedings led to more bitterness in his relations with his wife. You can say like that. This is the language we have to understand, and we have to try to use these words. Now next is easy word, cease. Cease is like a finish or terminate. A person who ceases to be director of the company before filing of the case. Obviously 138 cases mainly cannot be made accused. If the accused who was not there for signing the check also there, and he was terminated or he has left the company, he ceases to be director, he cannot be made an accused. Gainsaying. Gainsaying means there are two options, or something like do rai hona. कोई दो राय नहीं इसमें. There is no gainsaying that there is a huge pendency in Indian courts. Huge pendency of the cases in the Indian court. There is no gainsaying. But इसमें कोई दो राय है ही नहीं. Everybody knows there is a pendency in our courts. Prone. Now this is the easiest one. North Bihar is the most flood prone area in Bihar. तो वो ऐसा एरिया है कि मोस्टली वहां पर आता ही आता है, फ्लड आता ही आता है. Now myriad, there can be myriad. Myriad means innumerable, असंख्य. There can be myriad situations which result in unfair and unreasonable bargains between the parties, especially in matrimonial disputes or civil disputes. Myriad situations will result in unfair and unreasonable bargains. It may be because of the child they are bargaining. Hitherto the respondent was regularly coming to the court. Hitherto means until now he was coming regularly to court. Today he was not present. See, you making an exemption application before the court, you can always use this one. Hitherto the respondent was coming regularly to the court. Contours. The contours and curvature of the land is same as was few years back. Now contours is like shape of any place. Now contours and curvature of land is same as few years back. Because the land property has not changed, you can use this word in civil dispute. Inscribed. Now again a very easy word. Due to the typographical error, the word respondent number 2 is wrongly been inscribed in place of respondent. Many times there are typographical errors. We can always use this word. Due to typographical error, the word respondent number 2 is wrongly been inscribed in place of respondent, the word respondent. Now next is asserted. Assertion, you also the accused asserted or the complainant asserted. The respondent asserted that he had always taken good care of his family. It is a statement made with full of confidence. When you are saying that I have said this, I'm asserting this, making a statement before the court. Or it may be an affirmation also. The respondent asserted that he had always taken good care of his family. Now next is virtue. By virtue of section 13B, that is Hindu Marriage Act, it's important that parties stay separate for a year before filing of the case. If you have to file a case for a mutual divorce, then under section 13B of Hindu Marriage Act, there should be 1 year separation. So these are very important and I would say ornamental words. If we are able to use these few words also, it will actually give a very good look to our language. See, we always say that why we should use simple words. That is true. But then you are in legal profession, noble profession, where if you use good words, it is bound to impress. Your language is your another way of impressing the court and asking for relief. See, whenever we go to court, we are making prayers. Now, it is not that easy also. So always remember, whenever you go to court, try to speak good word, good language. See, we are always impressed. In cricket, I believe Sidhu speaks very good English, and also even his Hindi command is very good. So why we remember him or why we appreciate him? The reason because his language is actually really very good. So always remember that it is very important that you start learning these words, and these words you can be you can take down these words from any judgment. So if you read judgment from a one judgment, you can always take at least 10 words. And these 10 words you can use, try to rewrite it again and again by using some sentence, and this will actually will give you little bit of the words and the power to impress upon the or persuade the judge with the good prayers also. I hope this was all about today. Anybody has any questions?